we'll give you the choice. You can make an argument this morning, or you can submit it on briefs, whichever, it's your choice. We're perfectly happy to hear you argue if you want to.
I appreciate that. I'd like to argue if that's okay.
That'll be just fine. Yes.
May I start this question? First, I'd like to say it's always a great honor to be before the Court of Appeals. I don't take it for granted. I'm here as the appellee. I represent Michael Gordon. This was a long, arduous, complex divorce matter. It was over 4 years. And the late Judge Smith, his untimely death resulted in it being transferred to the Honorable Philip Robinson. I practiced extensively before these two fine judges. The late Judge Smith was a trial court specialist in family law. It's a very hard designation. And he sat in Fourth Circuit for years. Fine judge, very thorough, very careful in his rulings. And the late, and Philip Robinson as well. I still practice before him. He's an excellent judge. He's very thorough, very detailed, and just it's an honor to be, to have an opportunity to practice before him. The appellee first argues that the Rule 3702 was improper. That was a default judgment. This court, I would argue, has affirmed several decisions where trial courts use the Rule 3702 to impose sanctions.
Counsel,
Yes, sir.
Was there a 5-day, or was there a written notice or 5 days notice with a written notice before a hearing, before the default was issued in this case?
There was not. There was not a 5-day notice. This was the judge made this ruling after the Ms. Gordon failed to answer very basic elementary questions, such as what is your name, what is your address.
So, I understand you need sometimes to sanction for failure to comply with discovery, but I always thought of the concept as sort of a gradual increasing of the pressure to get compliance. Here, we seem to go from the deposition to DEFCON 1 almost immediately. Because the deposition was going on, the judge was called, judge says, come to the courthouse, and then, bam, we're not talking about, a presumption, or we're talking about default just right away and pleading stricken. That seems to really have skipped over some steps to me. Why, or should we not be concerned about that?
I understand. At first glance, it may seem draconian, but you need to understand the history of this case. Ms. Gordon made false allegations of sexual abuse throughout the trial. That resulted in the military, forcing the military to engage in an investigation, which resulted in a 1-year delay, 1 year, that my client could not see his son, and he also was decommissioned. He's a major in the U.S. Air Force. He's fighting for our freedom, yet he couldn't see his son.
Well, granted, so I'm not condoning the behavior here that the court found, but why wouldn't a different sanction have served much the same impact here? For example, saying, okay, you're not allowed to put on any proof of
That's
adultery.
exactly what the court stated. The court ruled
But
that
then the court went on and said, I'm striking all pleadings, which meant any affirmative relief that she was requesting also went out the window.
she didn't. Judge Robinson correctly found that Ms. Gordon did not meaningfully participate in her discovery and her depositions. I was forced to take her deposition because she didn't adequately give me answers in her discovery. She hid behind the false military allegations that she made, which result in, and then she's
I'm not
explained.
suggesting, I guess I'm not suggesting that, her behavior and not taking the fifth to every question of the deposition was appropriate. That's beside the point. Let's
Yes, sir.
assume for the sake of argument, it was all inappropriate. I'm talking about the way a trial judge should approach a sanction in that instance. I mean, ordinarily, again, it's a ratcheting up, not a, we're going immediately to the most severe. I mean, wouldn't you agree a sanction post here was the most severe that can be opposed
I don't think
for
so.
a discovery abuse? I mean, short of, I'm going to put you in jail until you answer these interrogatories, I guess would be slightly more severe. But, I mean, this basically, all the pleadings were stricken, correct?
Well, if they're 3702 says contumacious behavior, willful and deliberate violation of the orders, or delay.
Yeah.
1 year.
And so when in contumacious behavior, that typically means a series of acts here. So were there any acts?
Let me explain the series of acts.
Well, let me finish my question
Yes, sir.
first, please.
Yes, sir.
And then you may answer.
Yes, I
Okay.
apologize.
The series of contumacious here, would that all stem from the deposition then? Or was there a series of events before that that the court made findings about?
There was the court in one of its orders in changing custody reviewed the transcripts from the order of protection where Ms. Gordon had filed an order of protection against Mr. Gordon, and it was dismissed. We had an Okaloosa County detective, so she had sought law enforcement. She had made a false allegation of sexual abuse and physical abuse with law enforcement in Okaloosa County where my client was stationed. And the detective was at a conference and was kind enough to testify for me before the Judge Ballinger because she felt so strongly about this case. The judge also reviewed all of the Air Force investigations, which were extensive. It took a year. We had to track those investigations. And also, Ms. Gordon had falsely claimed that she was disabled. She had falsely made that claim in pending ELITI support hearings. She had falsely claimed that she was disabled and could not work. And when I filed a motion asking for a vocational expert to examine her, the report revealed that no, she was not disabled. So she had lied to the court and perpetuated fraud upon the court when she stated that she was disabled. So there was a great history of lying to the court and her credibility being damaged. Her actions hampered my client's ability to be promoted in the military, hampered his ability to earn more money and to be promoted within the military. Her actions were far-reaching. So when I took her deposition and she did not answer at my office, I called the court with Mr. Tennyson present, and he did not object to seeking instructions from the court. That was her counsel at the time. We were instructed to go to the courthouse and have the depositions conducted there. During, I'm so sorry.
Side,
Yes.
no, on the technical
apologize.
side of that, though, so
Yes, sir.
let me read you some language here from Christie v. Christie,
Yes, sir.
decision of this court.
Yes, sir.
The notice provisions of Tennessee Rule of Civil Procedure 5501 apply even when a default judgment is issued pursuant to Tennessee Rule of Civil Procedure 3702 as a sanction. So, and at least Christie v. Christie is saying that the notice provisions of 5501 are going to be applicable under 3702. And so if that's, and Christie v. Christie's telling us they apply, then why don't we have a notice problem in this case? And if those notice requirements are applicable to 3702, and don't we have a foundational notice problem here? I mean, you noted that there wasn't written notice provided with 5 days before the default judgment was issued, and Christie seems to be saying that those notice provisions are required even if it's a 3702 sanction. So don't we, based upon Christie and based upon 5501, don't we have a notice problem here? And why isn't Ms. Gordon correct on that point?
I would submit that she was put on notice when she was given 3 different opportunities to answer the questions at the courthouse. So we were called into court on 3 different occasions. She was admonished by the court. She stated she made absurd allegations. She stated that witness tampering was an issue. She stated that she had to assert her Fifth Amendment privilege because of the military
Would you agree the
investigation.
default judgment was for the discovery or declining to cooperate in terms of answering the questions? That's the reason the trial court
But
gave.
it's
for-
also based on a delay. So the delay in this case was significant because Ms. Gordon filed an order of protection that was summarily dismissed after a trial on the merits. She then appealed that order of protection. That order of protection prevented my client from seeing the child, having any visitations. She also then, the military investigation was a year-long investigation, so the delay was excessive.
When the trial court judge
Yes, yes, sir.
decided to award a default judgment, you hadn't filed a motion seeking a default judgment at that point. This was a sua sponte action by the trial court judge, correct? And you come into court, you get the trial court judge to, the trial judge apprises, or you need to answer these questions. She persists in declining to answer the question that day.
Yes, sir.
And you hadn't filed a written motion, so.
That is correct.
So the
Yes, sir.
first
That is
time that anything's being presented to her that, in terms of any kind, and that's not even a writing, but is that day she's being told default judgment if you don't answer these questions. And so we're back to no written notice here, right? I mean, if Christie says the rules of 5501 apply, even to 3702 violation or sanctions, I'm struggling to see how they were complied with here. And maybe you're right, this would have been a great case for a default judgment, but did this sort of trip over the first step in terms of there's just no written notice here in compliance with 5501? And maybe everything you're saying, I'm assuming for purpose of argument, it's all correct, that this would have been a perfect case for a default judgment. But didn't we fall at the first step here in terms of that notice requirement?
I would submit that courts have wide discretion in imposing sanctions. And when a litigant does not obey a court order and delays and causes severe delays, which is the case in this case, refuses to even answer elementary questions, was given great opportunities to answer these questions 3 different occasions.
Is there any authority you can point us toward that would say, because then Christie looks problematic, to me at least on initial glance, in terms of your argument. Maybe I'm misreading it, maybe I'm mislooking it. Is there any authority you can point us toward that would say that when a trial court judge is acting sua sponte, the 5501 notice requirements are not applicable, that you don't have to have 5-day notice before issuing a default judgment?
I would cite Kelly v. Kelly, which is a case out of Fourth Circuit Court. Stanley Queller, the Honorable Stanley Queller, was the judge. M2 2023 00598 COA R3C.
And I think Judge Smith was also on that case.
It was Judge Queller.
Yeah, well, Judge Queller finished it up.
Yes, he
but
did.
Judge Smith started with it.
You are correct, Your Honor. And oddly enough, I was counsel at one point for Mr. Kelly. So I know Lisa Webb was his trial counsel and represented him on the Court of Appeals. And in that case,
Counsel, let me.
yeah, I'm so sorry.
I'm not familiar with the case.
Yes,
Judge
yes,
has
sir.
decided, but I'm looking at Rule 55, and I'm trying to see why 5501, why the language, and I'm just not familiar with that case. That's my fault. But when a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend as provided by these rules, and the fact is made to appear by affidavit. I mean, that's not the situation we have here, is it?
I'm sorry.
The default judgment was not made because opposing party failed to plead or otherwise defend.
Ms.
Your
Gordon.
answer ought to be yes.
Yeah, that is correct, yes.
Okay.
Ms. Gordon, I want to be precise in my response. Ms. Gordon did file her counterpetition. It wasn't a default in the way that she failed to answer and
said
submit her
answer.
pleadings to the court. That is correct, yes, sir.
Okay. I guess I'm just trying to understand, and I hope I may
Yes,
have written
sir.
that opinion. I don't remember.
Yes, sir.
And so that would point to
Yes, sir.
an argument that maybe Christie is incorrect on on this point in terms of 5501 being applicable to a 3702 sanction, that possibility based on the language. And maybe Christie's not, I mean, it's not a published decision, it's an unpublished decision of that court, of this court.
Well, in this case, Kelly v. Kelly states, with regard to 3702, a default is an extreme sanction, but a default is appropriate where there has been a clear record of delay or contumacious conduct. I always have a difficult time saying that, I apologize. And in this case, there was a clear record of delay, and there was a clear record of disregard for court orders throughout the proceedings.
No,
And
excuse me.
yes, sir.
I think we understand your argument at
Yes, sir.
that point. But the court told her to answer these questions.
Yes, sir.
Correct.
Yes, sir, that's correct.
The lawyer told her to answer these questions, correct?
Yes, sir, that is correct.
She still refused to answer the questions.
Yes, sir, that is correct. I'm sorry, I'm leaning in because I was having a hard time hearing you earlier, so I apologize. During the court proceedings, after Ms. Gordon failed to answer the questions, the court gave her a lot of latitude, and I thought the court spent a lot of time explaining to her the need to answer the question and why her Fifth Amendment privilege wasn't appropriate. And I just remember the court reporter bringing her machine into the courtroom, and it was a long and lengthy conversation each time, and there were 3 different occasions where this occurred. So there was a great history before that had occurred, the court was certainly aware. The court found Ms. Gordon not to be credible because of her dishonesty, and I would submit when you make a false allegation of sexual abuse or physical abuse, it's probably
I don't think anybody is arguing that what
Yes,
she
sir.
did was right or
Yes,
might not have been worthy of default. I think
Yes,
the
sir.
question is whether
And-
or not she was entitled to 5 days' notice.
Yes, sir. I understand where the court is going on this, on the notice. I would just respond, and I'm out of time. Well, I'm almost out of time. I don't want to be inappropriate, but I would just submit that courts have wide latitude under the rule, and the court can look at whether or not there's a delay or disregard for court orders. And there's consequences to not following the rules. And there's consequences to not fully and meaningfully participating in discovery or depositions. And you can't play games with the court. You can't assert your Fifth Amendment right when someone asks what your name is and why you're arguing adultery, why you're seeking a judgment for attorney fees, why you're seeking custody. Where do you live? All those
We
things.
understand your time's
Yes,
expired.
I apologize. Okay,
That's
thank
okay.
you so much for the opportunity.
Yes,
Okay,
we appreciate your argument today.
thank you very much, and I am very appreciative. Thank you.
If you would, recess court till 1 o'clock this afternoon.